You draw districts in such a way where Black voters are basically never in the majority. So you spread out the Black voters, right, and the minority voters into a bunch of different districts to basically dilute their votes.
So Leah Litman is a awesome University of Michigan law professor. She told me right now that she doesn't have too much juice on her phone. So I said, Leah, just do what you can, plug it in, and hopefully she's going to come in right now. Leah also has a fantastic book that I want to shamelessly promote because she sent it to me and it's so good. Hold on 1 second. Leah's book is Leah. How are you doing? Um, you
Good.
you
Sorry,
saw
I'm
me
just plugging
awkwardly.
this in.
No, it's one of those days. I actually pressed live and was staring vacantly into space, not realizing people were staring at me for 30 seconds. And then I was like, oh, I'm live. My mistake. But I was
There you go.
shamelessly promoting you. And I was about to promote your best-selling book. It's called Lawless: How the Supreme Court Runs on Conservative Grievance, Fringe Theories, and Bad Vibes. I had Leon when she published it a couple of months ago. It is a fantastic book that literally encapsulates all the bullshit and captures the moment that we're in right now. Because the framing of today, Leah, I said, and you might disagree with me. I don't think you will, but if you do, please, I welcome it. How the conservative majority of the Supreme Court is sharpening its blades for Trump's hatchet job on democracy. And I've been, there's little snippets here. There's little snippets here, Leah, breadcrumbs. I know there's so many fires that are burning and not everyone can follow it. But there's one big one that I want to throw out there. As everyone talk about gerrymandering, and Donald Trump goes, I win 150 new House seats, and people are talking about Prop 50 in California and Republicans in
That was a
Texas.
really good Donald Trump accent, by the way. Just
I,
wanted to compliment you on that.
I thank you. I think, and now you're seeing Virginia respond. There's something called the Voting Rights Act, and the Supreme Court. Oh, in their oral arguments seems, I don't know, Leah, to be like, Voting Rights Act? Aren't we post-racism? Let's gut the Voting Rights Act. And even me, a recovering attorney, I remember that John Roberts, the alleged moderate, has had a wet dream for about, 35 years to destroy the Voting Rights Act. So can you please tell people why a person like me is so concerned about the Voting Rights Act and how it lines up with this gerrymandering, this path of gerrymandering towards the midterm election?
Okay, this is a long story, but it is an important story. So please feel free to interject at any point.
No,
So,
continue.
okay, it begins with the Voting Rights Act of 1965, like the most significant and most successful piece of civil rights legislation in this country. The law that turned the United States into a multiracial democracy. Because the Voting Rights Act prohibited states from denying people the ability to vote on the basis of race. And immediately when it went into effect, the Voting Rights Act is like super successful at getting rid of things like literacy tests, or when states would tell people you have to count the magic number of beans in the jar before you're allowed to vote. But what ended up happening is once states were blocked from basically keeping Black voters from being registered and keeping them from actually voting, they came up with ways to ensure that Black voters were still locked out of power. And that method was gerrymandering. You draw districts in such a way where Black voters are basically never in the majority. So you spread out the Black voters, right, and the minority voters into a bunch of different districts to basically dilute their votes. And allow them to be outvoted by the white conservative majority that you create in all of these districts. So seeing that this is happening, voting rights advocates, civil rights organizers, and Congress thought we need to get rid of this gerrymandering phenomenon whereby states draw districts in ways that dilute the voting power of racial minorities, again, effectively making it so they could never actually elect the candidate of their choice. And an amendment to the Voting Rights Act is proposed. At the time, the president was Ronald Reagan. And Ronald Reagan didn't really want to expand the Voting Rights Act. Surprise, surprise. And so he turns to the lawyers in his Department of Justice, one of whom is John G. Roberts Jr., to write memos opposing this expansion of the Voting Rights Act to protect against racial gerrymandering, to protect against diluting the voting power of racial minorities. And so John Roberts writes memo after memo, right, saying, like, we don't want to interfere in states' electoral systems. We don't want to establish a right to electoral representation for Black voters. Those memos are unsuccessful. Congress overwhelmingly passes with bipartisan support the Voting Rights Act. And Ronald Reagan gives in. Like, he signs this amendment expanding the Voting Rights Act. It is that provision that expanded the Voting Rights Act to safeguard against gerrymandering and drawing districts that have the effect of diluting the voting power of racial minorities that is now at issue in this pending Supreme Court case, Louisiana versus Kelly. Now, I'll get to that like in a bit, but there's like even more of an evil villain aspect to this story that I want to get out, which is more than 10 years ago in 2013, the Supreme Court, in an opinion by one John G. Roberts Jr. in Shelby County versus Holder, dismantled what was known as the pre-clearance process of the Voting Rights Act. The Voting Rights Act always had two components. One was the pre-clearance process, Section 5. The other was Section 2, the nationwide prohibition on different forms of voting discrimination. So back in 2013, the Supreme Court dismantled the pre-clearance process, Section 5, saying we no longer need pre-clearance. Why? Because we still have Section 2, this nationwide ban on voter discrimination. And so that's going to be enough to kind of solve this problem of voting discrimination, in the absence of pre-clearance. Well,
they deliberately diluted it. Is that a fair thing to say? They deliberately weakened it.
Oh, well, they dismantled Section 5. Like, it no longer exists. The states with especially bad histories of voter discrimination no longer have to get the federal government's permission before changing their voting laws or policies. People are complaining about like a chirping noise or bird in there. I don't think it's me. I'm just on my AirPods and like I don't think that's me. But anyways, apologies about that.
It might have been me typing for 30 seconds and telling people to join Leah because she's saying smart things. So forgive me.
Okay. Or honestly, it's John Roberts and Sam Alito, and they know they're having this conversation, and like, who knows what the exactly. Who knows what kind of bugs they've deployed. But anyway, so this brings us to Louisiana versus Kelly, and this case is one of a series of cases that arose after the 2020 census and redistricting. So after there's a census, states basically have to redraw their legislative districts to ensure, there aren't too many people in one district and like too few in another. And so Louisiana drew districts. There are 6 congressional seats in Louisiana, drew congressional districts where Black voters would only be able to have political opportunities to actually elect candidates in 1 out of the 6 districts. That map was challenged as a violation of the Voting Rights Act because Louisiana could easily have drawn a second majority-minority district where Black voters would have had an additional opportunity to elect the candidate of their choice. The Louisiana map with the 1 congressional district where Black voters had political opportunities, that was struck down as a violation of the Voting Rights Act. Same thing with a map out of Alabama, a map out of Georgia, a bunch of states, surprise, surprise, in the former Confederacy, drew maps that attempted to lock out minority voters from political power. So what happened after courts then concluded that these maps violated the Voting Rights Act? Well, the Louisiana legislature said, well, give us a shot at drawing a second set of maps that actually complied with the Voting Rights Act, but still allowed us to accomplish our objectives, which included things like protecting certain congressional representatives from having their seats become competitive. And one of the people that Louisiana wanted to protect is Speaker of the House, Mike Johnson. Right? They drew a set of districts that ensured Mike Johnson would still be in a safe Republican seat. But they drew other districts such that there were now 2 districts where Black voters could elect candidates of their choice. So these new maps, the one with 2 majority-minority districts, are then challenged by a group of white voters who argue that it is unconstitutional to remedy violations of the Voting Rights Act by requiring legislatures to take into account race by ensuring they're not diluting the voting power of racial minorities. So they argue the Voting Rights Act itself is a form of unconstitutional racial discrimination because it prevents legislatures from discriminating against Black voters by diluting their political power. That is the issue that is now up at the Supreme Court. Is it constitutional for the Voting Rights Act to require legislatures to ensure they're not drawing districts in ways that underrepresent Black voters? I can talk more about kind of like the implications of the case or some of the things that the justices said during oral argument, but just a quick note on the implications. Right now, one meaningful limitation on Republican legislatures' ability to engage in partisan gerrymandering is the Voting Rights Act. Because the Supreme Court said in another decision back in Rucho, when legislatures draw districts to maximize partisan advantage, where they're trying to, advantage Republicans and not Democrats, that's basically something federal courts can't do anything about. But when Republican legislatures do that, when they try to maximize their partisan advantage, the Voting Rights Act has to date limited their ability to dilute the voting power of Black voters. Now, right, if you remove that protection, then Republican legislatures will be able to erase a bunch of districts where minority voters have political opportunities that will allow them to engage in even more extreme partisan gerrymanders that lock in and entrench Republicans' control. We are seeing that play out in North Carolina, where the North Carolina state legislature, they already have like a really freaking bad partisan gerrymander that ensured Republicans had safe 10 seats and Democrats would only have 4 in a state that splits like roughly 50-50 and routinely elects Democrats to statewide office. But apparently that wasn't good enough for the Republicans. So they redrew a set of maps, and this one has 11 safe Republican seats and 3 Democratic seats. And whose district did they take away? A Black congressional representative in a district where a majority of voters were Black, where Black voters had the opportunity to actually select their candidates. So these new maps, they dilute the voting power of Black residents in North Carolina by spreading them across a bunch of different districts. And that is the future we are potentially looking at in the event the Supreme Court does away with what remains of the Voting Rights Act.
And they are. Let's just be honest.
Oh, yeah. No, they're doing it, right? Like, I don't know how they're going to do it. They could do it a bunch of different ways, but they are either going to make it impossible to prove a violation of the Voting Rights Act. Happy to talk about their cockamamie theory that would do that. Or they're going to make it impossible to remedy a Voting Rights Act violation. Again, many options on the table. They're going to pick one of them, but the upshot is going to be the Voting Rights Act no longer is going to provide the kind of meaningful protections that it has.
Yeah, sorry about that. Natasha's in the comment section right now. She goes, well, with John Roberts, where there's a will, there's a way. And that's absolutely on point. I think that's a very astute understanding of how these right-wing hacks in the Supreme Court work, is they will manufacture a mean to the end that they want. The Constitution to them is Play-Doh. Originalism is there when it suits them, and it's not there when it doesn't suit them. And, if you just step back, folks, and thank you, Leah, that was an awesome explanation. That was a very excellent, scholarly, fantastic, like DeLorean ride through the Voting Rights Act. Or what was the Voting Rights Act, let's be honest, because they're going to gut it. It all goes back to, and I know people always think I'm crazy, it goes back to white supremacy. It goes back to racism. It goes back to a certain segment of the society that has lost its mind, that Zohran Mamdani might become the mayor of New York, that lost its mind when Barack Obama ascended to the White House, that lost its mind when Black and white people can marry with Loving v. Virginia, that lost its mind with Martin Luther King and the Civil Rights March, and that really lost its mind with the Brown versus Board education ruling that said that segregation in schools was unconstitutional. And it seems to me, Leah, and this is my take on it, you tell me, is that if you look at the states, it's those southern states that seceded and said, what? Black people as humans? We would rather secede from the United States of America and declare war against our fellow countrymen than dare see the Blacks as equals. And you look at that map right now, it's like, oh, wow, shocking. It's those same southern states. So maybe racism has a part to play here. And I've been saying this for 10 years now when it comes to Donald Trump and the MAGA project, they want to take this country back to 1953. And I could be wrong, Leah. I might have gotten it off by 100 years, maybe
Honestly, like 18.
1853.
I was just gonna say, I'd subtract like 100 years from that, but yeah.
Yeah, and so I mean, it's so naked, right? Because you do a juxtaposition of this. And then, because I like to bring the receipts, I know through the emergency docket, which you talked about, we'll talk about it a little bit more, so just so people know what's happening. Brett Kavanaugh, and they usually haven't really spoken out about this in the emergency docket. They just give Donald Trump the green light. But the Trump administration essentially asked ICE, asked the Supreme Court to allow ICE to engage in racial profiling. And we can't use race to equalize the playing field in education. How dare we do that in the United States of America? Oh, no, 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 we live in a post-racial society, and we can't look at race anymore when it comes to the Voting Rights Act because we elected Obama. What racism? But you can use racism to go after brown people. Can reconcile this for me.
No, like they aren't reconcilable unless you view like some combination of like colorblind constitutionalism with their view of whatever is going on with the Voting Rights Act as basically white nationalism or white supremacy. Because like part of what is so galling about the arguments against the Voting Rights Act is you have this fixation from justices, specifically Brett Kavanaugh, who insist that the 14th Amendment or the 15th Amendment, which prohibited discrimination in voting, they basically had an expiration date in that they only allowed Congress to enact legislation that safeguarded, the political power of racial minorities, that took race into account in order to ensure that Black voters were represented, that they only had the authority to do that for some limited period of time. But I don't hear him calling for an expiration date when he is saying that roving immigration patrols and ICE officers can engage in racial profiling, right? He seems to be fine signing off on that for some indefinite time period. And I don't think those things are consistent with one another. Again, unless you view, right, like legislation that is designed to include racial minorities in the polity as somehow more suspicious and more unconstitutional than you view like legislation that has the effect of disadvantaging racial minorities. Why would you think that? Again, right? Like there's an answer kind of staring at us in the face. And just like going back to what you were saying about, like maybe wind this back to like 1853, we have all heard about the Civil War and Reconstruction. I think what people might not realize is that, like, basically immediately during Reconstruction, there was intense opposition to the idea of including Black Americans, right, in the United States, allowing them to vote, prohibiting racial discrimination in places of public accommodation. And those objections were framed in terms of it is a violation of the honor and liberties, right, of the South, of the white former Confederates, to force them, right, to share their power with individuals, right, who had recently been enslaved, with the freedmen. And it was on that same basis that the Supreme Court in Shelby County, right, like invalidates the preclearance process. They suggested that that law violated this magic made up principle, the equal sovereignty principle, such that the law was actually unconstitutional discrimination against the former Confederate states because it recognized that they had especially egregious histories of racial discrimination in voting. So again, they always managed to invert the concepts of equality and discrimination, right? They treat the most significant, successful piece of civil rights legislation that made the United States into a multiracial democracy as itself a form of discrimination against the former Confederate states. That's why, like, we no longer have preclearance. And they're about to say what remains of the Voting Rights Act, that's unconstitutional discrimination against white voters.
There you go.
Again, like, just the image in their mind is there's nothing wrong when legislatures draw districts that overrepresent white voters. In Louisiana, right, like Black voters make up a third of the population. But Louisiana drew a set of districts where they could only elect 1/6 of the state's congressional delegation. To the conservatives, the Republican appointees on the Supreme Court, that's fine, right? Like, that's neutral. That's not racial discrimination. But all of a sudden, when you have this law that says, oh, actually, legislatures, like, you gotta draw districts that represent the fact that we are in a multiracial democracy, then that becomes unconstitutional discrimination. And that is the worldview that they are going to use to end what remains of the Voting Rights Act.
Yeah, and if folks are going to do it, I just want you all to be prepared. They're going to do it, okay? And I'm reading this analysis from the Washington Post and New York Times. The Republican conservative justices seem skeptical. I'm like, shut the f up. They're going to kill it, okay? Just like this. I'm just meanly or just giving you the cliff notes, all right? I remain skeptical about these arguments. They seem more prone to. Yeah, they're going to kill it. John Roberts has had wet dreams about this since he was a college student, right? This is what he was born to do. He wants to annihilate it. They're going to annihilate it, and they're going to use any justification for it. But what's happening, Leah?
And everybody knew, like John Lewis, right? Former Representative John Lewis testified against John Roberts' confirmation to the Supreme Court, and he did so by pointing to the memos that John Roberts wrote when he was in the Reagan administration. And what Representative Lewis said is like, look, okay, he's a smart guy, but it's totally clear he just does not understand like what is needed in order to make the United States a multiracial democracy, and that he is obviously hostile to that project. And he was right.
Natasha says, Waj, why are we living through a effing sci-fi movie with the worst evil villains combined? My response to you is it is not a sci-fi movie. It is reality. And yesterday I was on with Don Lemon, and I was talking about the Republicans revealing the Bond supervillain plot, like the most helpful Bond supervillains. And then we were talking about corporate takeover, and one of the guests was like, wasn't this the plot of actually a Bond movie? And I'm like, it was. Tomorrow Never Dies. If you look at the 1997 Tomorrow Never Dies plot, it's this billionaire oligarch who wants to take over the media, and by consolidating the media, right, advance his authoritarian agenda. Voila. But I digress. They have given the plot away, Leah, because we go back to last year. Almost last year, a little bit more than last year. And I've talked about this when I thought it was completely over, because I mean, look, I know the Supreme Court, I know where they're headed, but I thought maybe, just maybe, on a few egregious issues, maybe there might be a 5-4. And then I saw Trump versus the United States.
Yeah.
And then I saw them go all in. It even shocked me, and I'm rarely shocked, folks. They went all in giving Donald Trump, let's be honest, it was Donald Trump, not Joe Biden, not the president, it was Donald Trump, absolute immunity for core functions of the executive. Was essentially gave him a get out of jail free pass for the multiple crimes that he did commit, including violent insurrection, stealing confidential documents, lying about it, trying to literally calling Georgia Secretary of State Brad Raffensperger and finding the exact number of votes that would give him Georgia. We literally have the phone call, folks. Once I saw that, Leah, I'm like, oh shit. Like, this Supreme Court's all in. And then you saw Samuel Alito's wife hoist not just one, but two flags associated with January 6th. And then you saw Ginny Thomas, Clarence Thomas's wife, openly send supportive texts to Mark Meadows during the insurrection. I always feel like, I don't know, the Supreme Court should be like in the news every single friggin' day,
Yes, agreed.
based on just the evidence that I've just articulated in the past week. But then Clarence Thomas, about 3 weeks ago, and I'm sure you saw this headline, he said, precedent doesn't really matter much.
Yeah.
And I thought that was him like being very unsettled about what he plans to do. Your take?
Yeah, I mean, I think we are really seeing a Supreme Court that views itself as like unleash and unchanged, because like they don't think they will experience any consequences or political pushback for reaching these appalling rulings. 3 years ago, or no, 2 years ago at this point, the Supreme Court actually had another Voting Rights Act case that is identical to the case they are now hearing out of Louisiana. That case 2 years ago was out of Alabama. And what do they do in that case? They hold off invalidating the Voting Rights Act. That case came 1 year after they overruled Roe versus Wade. Their public approval ratings plummeted. And Democrats performed way above expectations in the midterms. So there was a brief period in time where it seemed like, oh, wow, if we do shit that the country recognizes is utterly lawless bullshit, um, they might actually elect people, right, who will limit our power. And alas, right, their kind of lesson or take home from the 2024 presidential election is we can do whatever we want and you guys aren't going to do shit about this. And of course, they're right with respect to the Republican controlled Congress and presidency. And I think that's why we are seeing, right, them come back for the Voting Rights Act, right? So soon after, right, they held off invalidating it. That's why we are seeing them delivering win after win after win against for the Trump administration on the shadow docket. That's why we're seeing them do this in like unexplained, unreasoned orders. They don't think anyone, right, is actually going to hold them accountable. And that's why you have Clarence Thomas being like, oh, yeah, stare decisis. That's stupid, right? Respect for precedent. Sometimes prior precedent is dumb. And if it's dumb, I don't have to follow it. Okay, well, like what decisions, like what prior precedent do you think is dumb? Griswold versus Connecticut, the decision invalidating a state ban on contraception, like that's the thing he's calling stupid and dumb, like basically people's ability to access contraception and women's rights. Like apparently those are dumb and stupid.
But have you noticed, Leah? Have you noticed? Roe v. Wade, stupid. Brown is stupid. Griswold is stupid. But he never talks about Loving v. Virginia.
Well, so Brown, right, he actually really he loves Brown versus Board of Education because they love to like twist Brown on its head and insist that Brown versus Board of Education is what requires colorblind constitutionalism.
Oh, okay.
Right, like their modern take on Brown versus Board of Education is actually it forbids school districts' efforts to integrate. Right, it doesn't just forbid schools segregation; it also forbids integration. So he loves Brown because he's come up with that great new twist on it. And I think like the Loving versus Virginia, the case you reference, is the case that struck down bans on interracial marriages. And of course, Clarence Thomas, is part of an interracial marriage. Now, the cases that feel like he has come after largely fall under the category of what's called substantive due process, decisions that protect certain rights or liberties that aren't specifically and explicitly like spelled out in the Constitution. And Loving was like also justified on equal protection grounds. So like he can point to like some other basis for the decision, but it's just remarkably convenient that like all of the cases that he doesn't like happen to like match up with the Republican Party's platforms on issues they don't care for either.
It's all Play-Doh, folks. He won't touch Loving v. Virginia because he loves Ginny and they're best friends. But they're gonna go after. I'm so glad you mentioned Griswold because that's what's next. And there's two cases I want to ask you about because people think I'm crazy. Maybe less actually people there saying I'm crazy. They were said I was crazy for 9 years, but now they're like, what? You might be onto something. This whole thing about martial law and Insurrection Act and National Guard, I didn't take you seriously, but you might be onto something. So now it's like the world's worst. I told you so. I know people who watch say that often. I get no joy from any of this. But also with Roe, remember what they said? No, they'll never touch Roe.
Oh, yeah.
They'll never touch Roe.
Oh, yeah.
No. And then so I say, all y'all who say they'll never touch Obergefell, why? Why wouldn't they? If I could get away with Roe, Leah, why wouldn't I go after Griswold and marriage equality?
Yeah, so I think that the way in which they are going to go after Griswold and marriage equality like looks like the first step, right, of overruling Roe, which is basically chipping away at it, limiting the scope of the right, et cetera, et cetera. So in the case of Griswold, the decision that struck down a ban on contraception and concluded that, there is a constitutionally protected liberty interest in being able to control like when and whether you have children. I think the move that we are seeing right now is state governments and also the federal government basically reclassifying certain forms of contraception as abortifacients, right? As in reality abortions. They're not, right? But that hasn't stopped, states or the federal government from treating certain forms of contraception as abortions. And when you do that, of course, like then a law restricting that form of contraception falls under the scope of the Supreme Court's decision overruling Dobbs, because the Supreme Court will just say, oh, right, they are limiting access to abortion, not contraception. And I think that is going to be like the initial path of restricting access to contraception. I also think, like, add to that, the Supreme Court's expansion of conscience exemptions, and them saying, like, individuals who object to abortion, individuals who object to contraception, individuals who object to marriage equality, like, they basically don't have to comply with civil rights protections, for those individuals. We saw
Yep.
this in the litigation against the contraception mandate. That's part of the Affordable Care Act, where the Supreme Court said employers who have objections to contraception basically don't have to cover, health insurance for their employees. That includes contraception. I think we are increasingly seeing that with respect to LGBT rights and marriage equality, where the Supreme Court has said it's actually unconstitutional to apply the state's civil rights laws, civil rights protections for the LGBT community to individuals with objections to marriage equality. So I think that, like, those are the paths, like, they are headed down right now. That are going to take, like, huge bites out of the protections of Obergefell, and the protections of Griswold. And, they already have, like, another case on their docket, this conversion therapy ban.
Yep.
Colorado has created a licensing regime for professional therapists that said, if you are a professional therapist who has a license in the state, like, you can't perform conversion therapy. This isn't a ban. This wouldn't, like, throw anyone in jail who performs conversion therapy. It's just like, you will lose your license as a medical professional, like, if you perform this, like, non-approved sanctioned form of care. And it is perfectly clear that the Supreme Court is going to say it is unconstitutional for a state to ban conversion therapy, because that represents, again, like, unfair discrimination against the poor souls who just so desperately, like, want to believe that you can counsel someone out of being gay or trans.
Not even counsel, but torture them. Torture
Oh
them.
yeah, UN experts. That's how they have labeled conversion therapy.
Yeah. It's torture, folks. They torture these kids, and it doesn't work. So in addition to not working, it's seen as torture, which is why it was banned. But they're like, oh no, religious freedom, and so they're gonna chip away, folks. And anyone who says, oh, Wad, you're crazy about Obergefell and Griswold, just trust the. It's just so frustrating, Leah. Like, it's like, what more do people need to, like? When people say, "Is Donald Trump racist?" I'm just like, I don't even smoke cigarettes. I just feel like taking like like what. It's like, can this happen here? But will they stay in power? But will he use the Insurrection Act? But is he gonna really run? I'm like, he's selling 2028 merch, mother effers. Like, I
Right.
don't have time for your stupidity. And like, this is me. Like I don't have time for you being this dumb. And they're like, can it really happen here? I don't know. Won't the
It
center
is
hold?
happening here.
Yeah, it is happening. It is happening. They already got rid of Roe. What more do you need to see? And furthermore, I know I only have a couple. Sorry, excuse
Like,
me.
look at the streets of Chicago. Like, look at what is happening there.
Portland. Portland's
Yeah.
hella white. I love Portland. It's like a giant bookstore. Even Portland is safe. All right. He's open. He 2 weeks ago when I asked, "Hey, are you going to use the Insurrection Act?" He didn't say no.
Right.
Pam Bondi didn't say no. Stephen Miller didn't say no. And now they're talking about 2028. And now Steve Bannon, yet again, I'm sure you saw that interview with him a couple of days ago, is openly telling you, oh, yeah, we have a plan to keep him in power. He's chosen by God. And so I know I have for you only a couple of more minutes. I want to ask you these final two questions about that. There is a unitary executive theory that these right-wing hacks in the Supreme Court believe in. We also know that they're Christian nationalists. I say this without exaggeration. And, dominionism, they believe that, they're on a mission from God. And Donald Trump is the vehicle, the flawed servant, right? That God has chosen for their endgame. Steve Bannon said that. The work isn't done yet. Talk to us about what the Supreme Court might do or might not do when Donald Trump, as he has literally said, will run for president a third time in 2028.
Yeah. So a few things on that. This is actually something that Justice Barrett was asked about during one of her interviews that she did, like, as part of her press tour for her book publicity and book promotion. And she kind of, like, became uncomfortable when asked about it and gave a fairly stilted answer where she
I
just
remember that.
said, oh, the text is clear. And I mean, I think like you should take from that that even she thinks like this issue is probably going to come before the Supreme Court, right? Like that's why she was hesitant, right, to talk more about it because the justices, right, at least those who aren't Samuel Alito, try to avoid, right, speaking publicly about issues that have yet to come before them but are likely. So like it's not just right like you or me who thinks like Donald Trump right is going to try to run for a third office. Like people who are part of these MAGA circles and Republican ones, they do too. So what would that look like? I mean, like we don't exactly know like what iteration it's going to take. It'll take one of two, my guess is. Either Donald Trump will say like, "Okay, I'm running for president." And the 22nd Amendment allows that because the 22nd Amendment just prohibits consecutive terms. And so it allows me two consecutive terms, right? But because I lost in 2020, query whether this would require him to admit that he lost in 2020, that because, I wasn't president in 2020, then therefore I can run for a third office because it would just be my second consecutive term. Alternatively, right, it looks like he has JD Vance run and Vance or someone else like agrees to resign. So Donald Trump, who would be their vice presidential candidate, can become president.
That's the plot. I'm glad you mentioned that because they already mentioned the plot. That's how they want to do it.
Yeah. And like again, like if you look at the 22nd Amendment, of course the 22nd Amendment doesn't say, someone who is president for two terms can't run as vice president and subsequently become president, because the vice president resigns because nobody thought they had to say that. No one thought they had to say that. And so, like I can frankly imagine, right? Like you get a majority of Republican appointees on the Supreme Court saying, well, the text of the 22nd Amendment doesn't straightforwardly prohibit that. And so, right, there's just nothing to see here.
And folks, I just want people to be prepared. That's what's going to happen. And it's going to happen much sooner than you think. 2026 is around the corner. They're going to start campaigning in about a year for 2028. If Donald Trump is still alive, I don't know. He looks really sick. That's the plot. They're going to have JD Vance run, and then Trump is going to be vice president. And then after JD Vance wins, and they're very confident that he's going to win, which is interesting also. They said that JD Vance will just step down, and then Donald Trump will become president. And then I'm pretty much sure that he'll probably make an arrangement with JD Vance and say, "Hey, you could be my vice president again." And if you think the Supreme Court won't let that happen, get your heads out of the sand, folks. In the final few minutes that I have, Leah, I do want to ask you this: Joe Biden, in the final month of his presidency, did something that I think Democrats should have been doing for 10 years. Is in some way, shape, or form talk about reforming the court.
Yes.
And he came out, if you remember, with this memo with a couple of points on it. I think it was 4 points, which I agreed with. Expanding the court wasn't on it. I'm all these centrists and moderates said, "Waj, you're radical." Everything was considered radical. Raising the wage was considered radical. Marriage equality was considered radical. Having a Muslim mayor of New York 6 months ago was considered radical. I think the people are there, Leah. They just need a champion and a fighter and someone to message. I was old enough to remember that abolish ICE was considered radical. And I cannot imagine, folks, in 2 years, a national Democrat leader running on pro-ICE. I just can't. If I'm wrong, let's see. But I'm going to go all in and make a prediction that abolish ICE or being not a fan of ICE is going to be a big plus for Democrats, right? So I was told, and you were told, we can, now, brown cow, you can't talk about expanding the court and doing this. No, that's mean. What more do we need to see, Leah?
I mean, I don't think you need to see anything else from the Supreme Court to understand the urgency of expanding the Supreme Court and having that be a part of a package of reforms that are necessary, right, to democratize the Supreme Court and democratize our country. What do we need to see? I mean, I understand wanting Democrats to win elections, right? I understand that. On the other hand, politics is the art of convincing people what they should care about. And so the idea that you can't talk about something as important as the Supreme Court's role in our democracy and the fact that the Supreme Court seems poised to dismantle the Voting Rights Act, that's insane to me. So what should we be doing? I mean, now is the time to like be talking to people about the Supreme Court and building a coalition, right? To actually want to expand the Supreme Court and narrow its authority, right, over our democracy, such that when Democrats next find themselves in power, like Democratic elected officials recognize their base cares and wants Supreme Court reform. And like their base has like picked, leaders who understand the urgency of Supreme Court reform. I'm not sure if that like totally answers your question, but that is like what I would like to see.
Yeah, and it does answer my question. I believe if there's a Democrat that runs on the Supreme Court that literally connects the dots for folks and said, "I'm going to reform the Supreme Court," I think it will be a huge boost for that candidate, folks. I think people will be like, "Yes, you're my type of guy or gal. I'm behind that." But let's see. Who am I? I've just been pretty right on a bunch of stuff. But I'm nobody. Leah, thank you so much for joining, folks. There's nearly 1,900 people watching. It took me 2 weeks to get her
Yay.
on. It took me 2 weeks to get her on, but I knew it would be good. And she's super busy. Before I let you go, I need you to shamelessly promote yourself.
So hi, Leah Litman. I co-host a weekly podcast about the Supreme Court called Strict Scrutiny. So if you want to know what these bozos are up to, you can tune in every Monday wherever you get your podcasts. I also have a recently released book, Lawless: How the Supreme Court Runs on Conservative Grievance, Fringe Theories, and Bad Vibes. I guarantee you, if you buy it, you will trigger some MAGA Republicans, probably including some on the Supreme Court. And you can get that wherever you get your books, including your local independent bookstore or bookshop.org, which supports independent bookstores.
In addition to triggering the worst people, more importantly, it is written. I say this as a compliment. It takes all these what are very complex issues and distills them in a very conversational and understandable prose. And it's about 250 pages, and with a sense of humor also. And it tells you, for those who don't know about the Supreme Court, and you have to know about the Supreme Court, folks. It's 6 unelected right-wing hacks who have been groomed, my words, for years, groomed by right-wing billionaire money to literally ascend to the Supreme Court and be the hatchet men and women for Donald Trump. And so Leah talks about the funding, she talks about the ideology, she talks about what they're doing and how they just treat the Constitution as their Play-Doh, right? Some days they're originalists, some days they're not. Some days precedent matters, other days, what's precedent? But the sad part is, folks, they are complicit with Trump's authoritarian agenda. And I do believe the more and more people know about it, the more and more pressure that is put on them, the more and more they need to feel that pressure, the more and more, inshallah, maybe we could keep them in check. And I'll end that FDR, you all remember, FDR said, "All right, mother effers, you're not going to go along with my agenda. I'm going to expand the court." And Leah, can you tell them what they did when he made that threat?
So what did the Supreme Court do when FDR threatened to expand the court? All of a sudden, they started upholding New Deal programs. They started upholding minimum wage legislation, maximum hour legislation, right? They saw, right, in their heart of hearts that actually that is what the Constitution meant all along.
Ha! Maybe playing hardball is where we, maybe we have to play hardball to save our hard-earned freedoms and so many people marched for and died for, folks. But that's just me. I'm crazy. What do I know? I'm a recovering attorney. But Leah Litman is actually a law professor. Thank you so much, Leah. Thank you all for joining us, about 1,900 people. For those who joined us late, I'm talking to Leah Litman, professor, author, legal scholar. We're going to have this conversation up on my Substack and her Substack. Please subscribe. Everything is free on the left hook because I'm a terrible capitalist. If you have a few dollars, spend it to buy Leah's book. If you have a few left over, I have, like like people mentioned, 800 kids and 3 cats. Let me feed 1 child and half a cat. So it'd be nice. If not, it's fine. I feel people should be informed. And so please at least spread the content. And I'll be back in about 15 minutes at 3 p.m. with Mike Madrid to talk about these latest poll numbers and specifically why all these Latinos and people of color are now jumping the MAGA ship and what, the resistance can do to actually campaign on a winning message. So that's at 3 p.m. Mike knows all the numbers. Some good news for you. Thank you, Leah, so much. I know you're so busy.
Thank you. Take care.
Bye.